Stanley's on his way and Tom is on his way. The boards need to open. We'll start with the ZBA. Who's chairman? Would you call your meeting to order?
Being 5:39, call to order the October 16th, 2025 meeting of the Plainville Zoning Board of Appeals.
Thank you. Mrs. Clark, would you care to open the select board meeting, please?
Call to order this meeting of the select board.
Okay, and the Conservation Commission.
Call Conservation Commission meeting to order, October 16th.
Did I get everybody? Planning board.
No quorum yet.
I guess it's going to be no quorum yet.
Yeah,
Okay.
wait,
So
Tom's
we'll have to wait until your quorum shows up and then quietly do that. Okay. So tonight there probably this is a public meeting because there's no reason why the public cannot observe the training that we do, courtesy of KP Law, which is the town's council. We have with us Amy Quissel, who's a partner for the firm, and she's a long-serving lawyer with good standing and great reputation, and she is now the direct supervisor of our former administrative assistant, Ryan Garabedian, who's in the back room and passed the bar last week. So congratulations again. We should be doing more board and commission training, and this is the most important boards here tonight that deal with quasi-legal issues. And I think it was more important to start with these boards tonight, and then we'll do other boards later as we need to and as we can book time with the law firm. But I want to thank Amy for being with us this evening. The idea of the meeting is for you to get a refresher course. Many of our members have been long-serving members of the board. This is a good refresher for what we can do, what we should be doing, what we can do in running a meeting and not violate the open meeting law. And there's also a little bit of ethics training thrown in for good measure, which I think we should do generally. Please feel free to partake of the pizza. I don't want to take any pizza home. Anybody who doesn't eat the pizza will be taking it home. So I appreciate that very much. With that, Amy, it's yours.
Thank you. So again, Amy Quessel with KP Law. This presentation what I do is I very briefly touch on what exactly each board does. I talk about making a defensible decision. Again, we then go into the open meeting law. We go into public records, a little bit of public records, and ethics, which cover all of the boards. So usually I take questions at the end, but is that the format you want to do, or do you want to have people do it while I'm presenting? It doesn't matter to me.
I think as you go, but
Sure, as I go, that's perfectly fine.
I think it's probably relevant and on top of their head to do that now, and if somebody's thinking the question, somebody else is too.
Great. So, so the land use, starting with the land use regulatory boards, we have 40A, which is the Zoning Act. We have Chapter 41, Section 81, and I think it starts at A to GG. That's the subdivision control law. And then we have Chapter 131, Section 40, which is the Wetland Protection Act. We also have, additionally, land use boards sometimes will implement certain local bylaws, such as the Local Wetland Protection Act, or the Local Protection Bylaw, sorry. So to start with zoning in Chapter 40A. Chapter 40A, what it does is it establishes a statewide framework for the regulation of land uses. It provides standard procedures to administrate the municipal zoning bylaws, and it provides municipalities with building blocks to help each community shape and preserve its character by encouraging appropriate uses of land. So the goals of Chapter 40A are public convenience, health, safety, and welfare. And the achievements of these goals are to have zoning districts with specific boundaries, uses of land and structures defined for each zoning district, and then dimensional requirements, which can be across town, or they can be for each zoning district or each use. Dimensional requirements can be a lot more flexible. And then conditions under which uses may be permitted. So those are your special permit uses. So the administration of the zoning act is the adoption of municipal zoning bylaws, which you do at town meeting. The issuance of various permits, you want to identify the permit or special permit granting authority in the zoning bylaw. And then again, in Plainville, the Zoning Board of Appeals is the special permit granting authority unless it's stated otherwise in the zoning bylaw. So what certain boards do under the zoning act is the ZBA does dimensional variances, they do findings under Chapter 48, Section 6, we sometimes call those Section 6 findings. Appeals from the building inspector, which is in accordance with Sections 8 and 15. Special permits, which is Section 9. And then comprehensive permits under Chapter 40B. The planning board does, they do under the subdivision control law, they do A&R plans and subdivision control. They do zoning amendments, which is under 48 Section 5, and they will do special permits if designated in the zoning bylaw. So with the zoning districts, when you establish zoning districts, you basically carve up the community into districts with specific physical boundaries, and you have to adopt a zoning map. Under 48, you have to have a zoning map. It has to be adopted by town meeting. The types of districts under your bylaw, under Section 12 of your bylaw, residential, single family and general, shopping center, general and roadside commercial, industrial, commercial, groundwater protection, floodplain, and town center. So you can have zoning districts on your zoning map. You can also have an overlay districts on your zoning map. So your zoning map you can either have one zoning map or you can have a zoning map with overlay districts, but it can all be on one if you want it to be. And then for uses, you have a table of principal uses. The zoning ordinance or bylaw must identify and define whether the uses are allowed by right, prohibited, exempt, allowed by special permit, or subject to site plan review. For use variances, use variances can only be granted under floodplain review, which is that's actually a requirement under FEMA and DCR. But under Section 6C of your bylaw, you do not allow use variances. By right uses are zoning ordinance expressly allows for a certain type of use of land in a certain district. On your zoning chart, it's under the letter P. So an example is single family dwelling units are allowed in the RA district and only building permits are required. So you're going to build a single family house in the RA zoning district. If you meet all of the setbacks, you simply go to the building department.
Sorry, just on the use variances.
Yes.
From the 48 allows you to do use variances, right? So what you pull from, that's from our local bylaw?
Mhm.
That's it?
48 says that you can grant use variances if it specifically says so in your zoning bylaw.
Yeah.
So if your zoning bylaw is silent on use variances, or it says you cannot grant use variances, you can't.
Yeah, so it defers to local bylaw, and we use the local bylaw.
Yeah.
on that slide.
It has to say, you know, the zoning board of appeals. Usually it's under the powers of the zoning board of appeals, and it will say the zoning board of appeals may grant variances, and then it will say including use variances or something like that. So it specifically has to state it. Prohibited uses is the zoning bylaw expressly prohibits a certain use of land in certain zoning districts. So, and that is on your table as O. So again, multifamily dwelling units are not allowed in any of the town's zoning districts except for the RD district. So that's the prohibited. And then, yes?
Can you go back to that last slide, please? That example, that's generally, or that's not for Plainville.
I think it is, but we'll check.
You allow it in RC by special permit too.
And we allow it in the town center district.
Oh, by right?
No,
So this is only by right. So I guess, well, no, you're
It's
right.
allowed
I
by
would
right,
say
you know,
if it's allowed by special permit, it's not prohibited. But you can't walk into the building department and get a building permit without previously getting zoning relief, which is, that actually ties into this next slide, which are pre-existing non-conforming uses. So these are uses and structures which lawfully exist prior to the adoption of a zoning amendment that makes them non-conforming. So they can continue, but if they are expanded, altered, or intensified, they need a finding that it's not more detrimental, and the protection can be lost if there's a significant change in nature, degree, or character of the use, or if a new nonconformity is created, they need a variance. So this is very complicated because a homeowner that has lived in their house for 20 years, they bought their house, they moved in, now they want to put on a small addition. And they can't just walk into the building department and get a building permit for this small addition because they're pre-existing non-conforming. So for example, their side setback, they're within the side setback. So they're pre-existing non-conforming, so they would have to come to the zoning board of appeals to get a finding. So it's a little bit more difficult for the actual, for the single family homeowner to, it's always a problem to explain to them, sorry, you've been living in this house for 20 years, but it is pre-existing non-conforming. So, and usually usually findings are they're usually granted depending on the situation, what the pre-existing non-conformities are. And so exempt uses, these are sometimes called Dover Amendment uses, which the zoning bylaw cannot prohibit, restrict, or unreasonably regulate. Those are commercial agriculture, religious purposes, educational purposes, childcare facilities. I'm going to skip over solar and go to ADUs. With regard to solar installations is a little bit different. It's not completely exempt. It's under solar, it says that a town cannot unreasonably regulate. However, there was a case a few years ago, the Tracer Lane case, where the Supreme Judicial Court said that solar is protected. It specifically said it's not Dover use, but it is protected. And so every single solar developer will come into town and say, we can do whatever we want. And that's not true. So that's the opinion of our law firm, that it's not. They can still be regulated, but they cannot be unreasonably regulated. Yes?
And you missed group homes can't be regulated.
So that's not necessarily under Chapter 48, Section 3. That's under the Fair Housing Act.
Okay.
But
Just changed recently
yes,
too, right?
Yep.
And mind if we pause just to call the planning board meeting to order now that we have a quorum? So Tom, what we did earlier was each board opened up their meeting once they had a quorum, so if you don't mind doing that.
Sure.
Whatever time it is.
Yes. 5:50. Yeah. Call the meeting to order for the planning board on October 16th.
Excellent.
Thank you.
Thank you. So moving on to site plan review. Site plan review is not in Chapter 48. It is it's a creature of local enactment, and it's widely used throughout the Commonwealth. I think all of my cities and towns use site plan review. And so site plan review is good to help review a project, and if it's an allowed use, it can be subject to site plan review, but it cannot be denied. Site plan review cannot be denied. So you can require screening, you can look at the internal circulation, you can look at landscaping, you can look at light impacts, but if it's an allowed use, it cannot be denied. Site plan review cannot be denied. And then special permits, those come under 48 Section 9 and Section 6B in your zoning bylaw. And special permits need a public meeting and a public hearing. You have to advertise mail notices under 48 Section 11. There's a whole process to advertise. Once an application has been advertised, a project proponent or applicant can request that it be withdrawn, but if it's been advertised, it can only be withdrawn with the assent of the special permit granting authority. So if somebody says, I just want to withdraw, they can't just withdraw and walk out. You have to allow them to withdraw. And that's because there's a repetitive filing provision under 48 Section 16, which says that if a project has been denied, they can't come back for 2 years without going through a whole process. So a lot of times if an applicant knows they're on the road to denial, they'll say, I want to withdraw this, and withdraw it without prejudice. And that can be done, there's no problem doing it, but it has to be done, the board has to accept that by a vote, it's a majority vote. Special permit, there is no entitlement to a special permit, they are discretionary. However, any denial has to be based solely on the bylaw. So special permits allow certain uses or relaxation of certain requirements upon the satisfaction of criteria if the use is in harmony with the purpose and intent of the bylaw. So essentially, when you're looking at a special permit, it's supposed to be not more detrimental to the neighborhood and in harmony and purpose with the intent of the bylaw. So again, an example is a special permit granting authority may allow a residential cluster development if the minimum of 40% of the development is set aside as open space. The interesting thing with cluster subdivisions is that is a special permit that's called out in 40A Section 9. So the state actually allows you to do a cluster subdivision. It also allows the town to issue a bylaw or to enact a bylaw that regulates that cluster subdivision. So some towns require 60% open space, some 50, some 40, and then the way that cluster subdivisions are, the way that they come to be is different. Some towns require a yield plan, some towns require a definitive subdivision plan. It's all different, but it is in the Zoning Act. So when you're reviewing applications, and this really does apply to every board, although I have this for zoning, you want to review the nature of the proposed project. So you want to know, is this residential, commercial, industrial? You want to know the relief that's sought. Are you looking at a special permit? Are you looking at a variance? You always want to have the current zoning bylaw and the current zoning map. You want to determine what district the property is located in. You want to review the plan for existing conditions and nonconformities. And again, that is very, very important for nonconformities. You want to note the required dimensional and use controls, and you want to determine if existing nonconformities will be increased. I find that applications that require the applicant to put the existing dimensional, the existing dimensions and the proposed dimensions, and then the required dimensions. So it's all in a chart. So, you know, they're asking for a 9-foot side setback, and they currently have, you know, a 20-foot side setback, and a 25-foot side setback is required. You know, they're already non-conforming at 20. Now they want to go all the way to 9. So it's much easier. I'm also not very good at math or numbers, so it really helps me with that. But when your decisions of a special permit granting authority, it requires 4 out of 5 members to vote in favor, so it's a supermajority. So if you have 7 members, it requires you have to have 4. If you have 9 members, you have to have 5. If you have 3 members, you have to have all 3. So the bylaw will list the applicable criteria. So it has to be, the site has to be appropriate for the use, size of structures, fits in the character of the area. The use will not adversely impact the neighborhood. You have to have adequate infrastructure provided, open space, and environmental impact. You can also impose conditions to address some concerns. So special permit decisions will have hours of operations. It can have times that signs, you know, must be shut off. You could have time for deliveries, screening, you know, traffic improvements, snow removal, things like that. And they must be voted and filed within 90 days of the termination of the public hearing, unless there's a mutually written extension filed with the town clerk. Almost every single deadline in 40A or 41 can be extended, provided that it's an agreement between the applicant and the town, it's in writing, and that extension is filed with the town clerk. The decision must be filed in the office of the town clerk within 14 days of the decision being made. The notice of the decision has to be sent to the applicant and all parties in interest, so those are the abutters that were noticed under 4811 in the beginning, and it has to be recorded at the Registry of Deeds. And then if there's an appeal of a decision, it must be filed in court within 20 days of the date the decision was filed with the town clerk. They also have to file a notice with the town clerk of the fact that they filed in court within 20 days, and that notice has to be within 20 days also. To overturn, the court has to find that the board acted arbitrarily and decision was not legally tenable. If a decision is reasonable under the bylaw, the court will uphold it, and the court could remand it back to the board. There could be a question the court doesn't understand why. So I just recently had one where the planning board issued a special permit for a solar installation, and they put a noise, there was a condition with noise that it could only go a certain level above 10 decibels. And it was appealed, the solar company appealed it, and the court remanded it back to the board for the board to explain why they chose that level of noise. So it's usually remanded when the court needs more information. This is the repetitive petitions that I've touched briefly on. If an application is denied, you cannot reapply for 2 years. And if you want to, you have to go through a whole process. So it's the permit granting authority finds by a vote of 4 or 5 members that specific and material changes and conditions exist, and all but 1 planning board member consents, and after notice is given to parties in the interest of the date, time, and place of when the determination will be considered. So it's quite a lot of hoops you have to jump through, which is why people will withdraw without prejudice. So moving on to the subdivision control law. The subdivision control law, it's been enacted for the purpose of protecting the safety, convenience, and welfare of the inhabitants of cities and towns, which is or may be put into effect by regulating the laying out and constructions of ways and subdivisions, providing access to several lots therein, but which have not yet become public ways, and ensuring sanitary conditions in subdivisions and, in proper cases, parks and open areas. That's for cluster subdivisions. The important thing to remember with subdivisions is you are only regulating the infrastructure. So you're only regulating the streets and the drainage. You are not looking at lots or where houses will be. You're not really even looking at the grading of lots. You are looking at grading when the grading has to do with the street and the drainage. But you're not looking at, where are you going to put this house, on what lot, and things like that. It's really just infrastructure. You can also look at how the subdivision, where the subdivision is coming in. So for example, what road is it coming off of, and what's the condition of the road it's coming off of, sight lines, things like that. So a subdivision is divided, it's defined in 4181L, and if someone wants to divide land that does not meet the definition, which is the definition is essentially you're creating 2 or more lots, you can do that through a so-called approval not required plan, which is an A&R plan. And an A&R plan is when a lot has sufficient frontage, and that frontage has been deemed to have sufficient access by the planning board. If a lot has frontage and that frontage is sufficient, your inquiry is over. It doesn't matter if the lot doesn't meet zoning. It doesn't matter if the lot it has wetlands in the back. None of that matters. The planning board under an A&R, you are only looking at, does this have frontage? Is it enough frontage? Say, for example, 100 feet of frontage is required. Does it have 100 feet of frontage? And is that frontage, is it accessible? If it's on a public way, all you do is look for frontage. You just say, okay, it's a public way, it has 100 feet of frontage, you're good to go. If it's a private way, the planning board then say, okay, you have 100 feet of frontage, but is it safe? If it's, a road that's barely a road, that's just a trail, say, there's a Nantucket case, the Perry case, that said that it was not accessible. A fire truck could not get down that road. There's other cases that say that frontage is illusory, which means that there's all wetlands in the front, so there's absolutely no way to get into the lot. There's another one that was in, I think it was in Brookline, and it actually it had a state guardrail in front of it, so access is impossible. So those are the only times really when access is actually illusory. But if it's on a private road, the planning board can decide if that road, if it's acceptable and safe to access that lot. Yes. Whoever's first.
What do you call it? In your presentation now, yes, you have to have the frontage, but in certain zones, don't you have to have the area also?
No, that's up to the building. That's up to the building department.
So you're telling me that if you're in an RA zone in the town of Plainville and you have 200-foot frontage and you only have 10,000 square feet instead of the 1 acre, that's a lot?
It's a lot, it's not a buildable lot.
You need 225 frontage.
225.
But if you have 225 feet of frontage and say 10,000 square feet, it's a lot, but it's not a buildable lot. So that person can get your endorsement from the planning board, they can even record it, it doesn't matter, but, or they then bring it to the building department and they say, I want to put a house on this lot, and the building department says no. So it's the building department that decides whether the lot is buildable.
Or the zoning enforcement agent.
It's however you guys do it in Plainville. It's usually the building commissioner when we always recommend that a zoning determination not be made until a building permit application has been filed. So usually it's once the building permit application's been filed, and then it would be denied. I mean, I guess they could go to the zoning board of appeals for a variance for lot area. However, they created the hardship, so I don't know how a variance could be granted. So it would be technically an unbuildable lot.
That was my question.
Oh, there you go. So the key statutory provisions under the subdivision control law, 81L has the definitions, 81P are the A&R plans I just talked about, 81Q allows the planning board to issue rules and regulations, 81R allows the planning board to issue waivers to certain subdivisions from your rules and regulations. So, for example, if you require a road that's 500, if a road it has to be 500 feet long, or it has to say it has to have a cul-de-sac, you can waive that requirement, provided that you're happy that the fire department is can turn around, etc. Waivers, a lot of times there's waivers from sidewalks on both sides. They'll come in, they'll say, can we just put a sidewalk on one side, and that's a waiver. Under 81O and T, those are the procedural. That's the procedural section about filing the application, the notice, the hearing, things like that. And then 81U and W are the 81U has the surety requirements, and then there's approval, modification, and disapproval. The surety requirements are associated with the approval. And then the quantum of vote to approve applications, again, we already went over the special permit needs a supermajority, A&R needs a majority, subdivision is a majority of the planning board, not a majority of those present. So if you're a 5-member planning board and you have 3 members present, you need to get all 3 members because it's a majority of the 5, not of the 3 that are there. Site plan review is just a simple majority vote. And if a motion to approve an application is made and it fails to achieve the necessary votes for approval, then the motion fails and the project is deemed to be denied. Speaking of somebody that is going to have to defend that decision, it's always better to have a motion to deny with findings. Because if it's a motion to approve and then it's denied, we have nothing to go off of. So we're going to get into it later, but if you are planning on denying a project, you think it needs to be denied, you have to come up with findings, you have to have a defensible decision. So we try and avoid this situation at all costs. Here we go, issuing a defendable decision. So, for either granting or denying, you want to identify the applicant, the property owner, you want to have the full address or, map, block, and lot, however you want to do it. You want to have the jurisdictional basis for your decision, so you want to state what bylaw section they're under. You want to have findings of fact required under the statute or the bylaw. You don't want to actually parrot the bylaw. So if the bylaw says that, this can be granted and it's as long as it's not more detrimental to the neighborhood, you want to say, this is granted, it's not more detrimental to the neighborhood because the house, in this particular area, all of the houses are close to the street, the front setback can be reduced, et cetera, something like that. Or there's no other houses around, and they're not going to see the fact that they're extending a pre-existing nonconformity or something like that. And then all of your decisions want to have language that says any relief not expressly granted hereunder is hereby denied. That's very important. And then you want to have your conditions and specific reference to plans. So again, you can always condition a decision, so you want to make sure that you do that, and if you do that, you reference plans. The Wetland Protection Act, which is Chapter 13140, and this is, Conservation commissions have it a little bit, it's a little bit confusing. They have, they're regulating a property under the Wetland Protection Act, but also under their local bylaw. So they're essentially issuing two decisions, but it can be one decision. It doesn't have to be two separate paper decisions, but they are looking at this from both the act and the bylaw. And so the reason for having a local bylaw is because it can be more stringent than the State Wetlands Protection Act. So you can have no alteration zones, you can have the 100-foot buffer zone be a resource area, and you can have protection of resource area values such as aesthetics and recreation, which the Wetland Protection Act does not allow. The types of wetland-related applications, so the other thing with wetlands is everything is initials. So you can have a request for a determination of applicability, which is an RDA, and the permit that's issued is a DA, which is a negative or a positive determination of applicability. You have a notice of intent, an NOI, and then the permit that's issued is an OOC, an order of conditions. You have an abbreviated notice of resource area delineation, which is an ANRAD, and the permit that's issued is an order of resource area delineation, which is an ORAD. So you gotta really know your alphabet there. So an RDA is when you go into the commission and you say, hey, am I in your jurisdiction or not? And the Conservation Commission will look at, they'll look at the actual plan to see if you're in jurisdiction and then what you want to do. So if it's, I just want to remove a telephone pole that's 99 feet from a wetland, you can come in under an RDA, and that could actually be a -3 determination, which is that yes, you're in our jurisdiction because you're within 100 feet, but the work that you're doing is not going to negatively impact. And it has to be a very negligible project to come in under an RDA. So I actually started serving on my Conservation Commission in 1991, maybe 93. We didn't have ANRADs then, so you had to do it under you had to do a wetland line under an RDA, but that's all changed now. You guys don't even need to know the history, but it has changed. A notice of intent is when you want to do something within jurisdiction. So you come in, you have a project that's 25 feet from a wetland, and you go in, it's a full hearing, and then the commission will eventually issue a order of conditions. It can be a denial order of conditions, or it can be an approval. A denial obviously will just have findings and then be denied. An approval will have findings and then conditions. And then the ANRAD is when you want to come in and you want to set your wetland line. You want to say to the commission, listen, we don't know what we're doing yet, but we want to set this wetland line, we want to delineate the wetlands, and we want you to confirm the wetlands. Once that ANRAD turns into an ORAD, that's good for 3 years. So that means that they can come in anytime within the 3 years, and that ORAD it's good. So even if the wetlands changed, unfortunately, it's good for 3 years, and we have litigated that, and it's good for 3 years. So the procedures for filing a notice of intent, you have to schedule a public hearing within 21 days unless the applicant agrees in writing to the extension. You have to open a public hearing within 21 days. I can't say that enough. You have to open it, because if you don't, you lose jurisdiction under your bylaw. And that is the Oyster Creek case. So there's 21 days to open it and 21 days to close it. If you miss either one of those, the opening or the closing, you lose your bylaw. So you're only under the Wetland Protection Act. They simply request a superseding order from DEP and they get whatever they want, because DEP gives you whatever you want. So you have to notice all abutters within 100 feet of the property line. It's in certified mail at least 7 days prior. At the public hearing, the applicant will submit proof of abutter notification either before or at the opening hearing. If more information is necessary, you can continue it. As long as you opened it within 21 days, you can continue it without the permission of the applicant, but only for another 21 days. So usually if you need more information, just make sure that the applicant is good with continuing it. So, and then if an applicant at a Conservation Commission, if an applicant requests the hearing to be closed, it has to be closed. And then the commission, if the commission can decide the proposed work does not meet the requirements of the Wetland Protection Act or the bylaw, you can deny the permit. you need to have findings to deny it. And the commission can also decide to allow the proposed work if, and issue conditions. You can also, you also need to be careful of the conditions that you're requiring, that the conditions follow the project and the property, because an applicant can appeal conditions if they don't agree with them. For an RDA, it's anybody can file. It can be the property owner, contractor, neighbor, concerned citizen can file an RDA. Problem with that is that we still have a Fourth Amendment. So somebody can file an RDA. It doesn't mean that we can go on their property. It's like a neighbor can file an RDA, but it doesn't mean that the board can go on private property without permission. So you can do it. It's not very. Doesn't always work when people want to do that. You have 21 days again to schedule the public hearing. You have to advertise within 5 days of the meeting, or 5 days before the meeting. You have 21 days to make a determination. And again, it's whether the work falls within jurisdiction or not. You can either, your DA can either be, determination of applicability can either be negative, which is good for the applicant, or positive, which means they have to file a notice of intent. So whenever you make a motion that you're issuing a negative determination, applicants always go, why? But it's actually good for them. So it's just the way it goes. The types of appeals under a order of conditions, when it's under the Wetland Protection Act, it goes to Mass DEP, and you request a superseding order of conditions, which is a SOC, superseding determination of applicability, which is a SDA, and then there's the SORAD, and then appeals under the local bylaw, those go to Superior Court, and those go to Superior Court under the CERT statute, which is 249-4, which is you have to file your appeal within 60 days of the decision, and then this standing order kicks in, and the standing order requires that within 90 days of the complaint, the commission has to file a record of proceeding, which is all of their entire file, minutes, things like that. And then the applicant files a brief within 30 days. We file a brief within 30 days of that, and then it goes to a judge on hearing. So there's no discovery. It is actually, nowadays, lately it's been quicker than other appeals. Sometimes it gets bogged down, but it's usually quicker. The commission has to, has to issue the order of conditions within 21 days. I think I've said 21 days like 21 times now. So it's the order of conditions, again, can be one permit. It doesn't have to be two separate permits. I think I only have one community that does actually 2 permits for each one. Findings are very important when issuing a denial. You have to make an effort to obtain information. Findings have to be specific to the project or the resource area, and it has to be more than just a recitation of the regulation requirements. So you don't want to say, the grading can't be within 10 feet of a wetland. You have to say they're proposing grading within 9 feet of a wetland, and so you have to lay it out. You should always issue a decision as if you actually have to explain it to a judge. You want to have it on paper. So you want to go through performance standards. There are performance standards in the Wetland Protection Act. Most regulations, most conservation wetland regulations have performance standards. You want to go through those. Order of conditions have to be recorded at the Registry of Deeds before work starts, and it's required proof of recording. And an order of conditions is valid for 3 years. An extension can be granted 30 days prior to expiration. For enforcement for conservation, we always encourage that if you get a report that somebody is violating the Wetland Protection Act, for example, they're filling in a wetland, the first thing to do is reach out to the person, telephone contact, something like that. You can issue an initial enforcement letter. And you can request that the owner, stop. You can also request that they come to a meeting and explain what they're doing. You can issue a violation notice, which is by, certified mail, which kind of ramps it up. And you notify the violator that an enforcement order containing a stop work provision will issue. And then the last thing is you can issue an enforcement order under 310 CMR 1009, that's Form 9, the DEP Form 9, which is formal enforcement. And the reason for this is because an enforcement order can be appealed to court. And so it's always good when we go into court and we say to the judge, listen, we tried, we reached out, we did this, we did that, they're ignoring us, they're continuing the violation. It just makes us look better that, we did try and work with people. So now we're moving on to the open meeting law. The open meeting law requires that an agenda is posted 48 hours prior to the meeting. It excludes Saturdays, Sundays, and legal holidays. It's advertised, any public hearing has to be advertised and posted 14 days prior. You want to track time to act and attendance of members, because if you miss one meeting, you can invoke the Mullen Rule, but if you miss more than one, you cannot, and therefore you could lose your quorum. And this is very important for long, controversial projects. For example, for 40Bs, it's for projects that are going to get continued and continued and continued, you have to make sure that you track your members and you make sure that you have the right members there. The chair will read the legal ad out loud for the petition, the application. The chair can explain certain procedures to the public. A lot of times during a public hearing, chair can limit the time for public comment. Limit it to 3 minutes, 5 minutes, 2 minutes. It's fine to do that as long as everyone is limited, every member of the public is limited. And you announce that. You don't have to, and you can also just do it for certain projects because of the interest in the project. You usually have the applicant present. You usually then have the board ask questions. You then can have public comment, department heads, town officials. A lot of times it's opposite. It's town officials, department heads, then public comment. What you want to do is you want to get the people that have reviewed it and know what they're looking at first and ask all of those questions first. And then you want to have the public comment. You want to then bring it back to your board, because public comment almost always brings up good points. So you then want to bring it back to your board, because you're going to have further comments or further questions usually. To deliberate under the open meeting law, it has to be, a deliberation is an oral or written communication through any medium, including email, between or among a forum of a public body on any public business within its jurisdiction. It includes email and text messages, even on your personal cell phone. And if you start anything with how do you intend to handle, if you ask me, we don't need another, and there's no way I will vote for. That's all, you're starting a deliberation right there. So don't ever do that if you have a quorum on your chain, whether it's email or not. There's also serial conversations, which is where if I email you and you and I are talking, we're not a quorum, and then that gets forwarded to the third member. That is a violation of the open meeting law. And social media posts could also be serial conversations where I comment, somebody else comments, somebody else comments. So here's the best way to handle things. Don't ever hit reply all, ever. Never hit it. And don't post on social media about projects that are before you, ever. It's not a good idea. Conducting the hearings, again, the chair will read the notice into the record. The chair takes testimony and evidence. The chair is responsible for maintaining order, and all comments and questions should be directed through the chair. You shouldn't have a member of the public asking an engineer a question. It has to go through the chair. Everything should go through the chair. You shouldn't have side conversations. The chair really needs to take control of the meeting. It truly makes things go much smoother. It really does. You then want to close the evidence and deliberate. And the deliberation has to focus on the contents of the hearing. So if it's an adjudicatory hearing, whether there was a violation, what action should be taken. A regulatory, you have to focus on what is the criteria, what are the local laws, and then you vote on the application or the enforcement, and you close the public hearing. A lot of times, a chairman will close the public hearing to, you close it to evidence, and then once you make a vote on the project, that's the end of it. You don't necessarily have to, again, close it. Site visits are not a meeting of the board unless the board deliberates. So my advice on site visits is don't talk to anybody. If deliberation is possible or expected, you will post the site visit just as you would an open meeting law. Problem with that is if the meeting is posted, you're going onto private property, so that owner of the private property has to allow all of the public on because it's an open meeting. So that rarely happens. You want to, if you do a site visit, you want to hold the site visit prior to the close of the hearing, and you want to report what you saw at the site visit at the next meeting. Whether the whole board was there or not, you want to report it because it's important for the public to know, et cetera. The other few things about the open meeting law is that you cannot talk about a project. So if a project is on your agenda, for example, and this happens, I think it's just, you know, how things go. If a project is on your agenda and that the applicant requests a continuance and the board is okay with continuing it, so the board continues the hearing, that's it. You cannot discuss that project again that night. Once a continuance is voted on, you do not discuss it, even if the applicant's in the room, even if the applicant leaves, if the applicant's in the room, you just can't do it. You might have the public there that's asking questions. You can say, here's the reason for the continuance, that's it. You can't take comments from public, you can't do anything. Once it's continued, it's continued. And then the other thing that we sometimes will see is an applicant will come in, they will request a continuance, and they'll say, we're requesting a continuance because we need to get the peer review report or something. And then the board starts getting into, oh yeah, you need the peer review because the peer review said this, this, and this. The applicant said, oh no, it said this, this, and this. You are now, there's testimony. You are taking testimony, which means you've established a quorum for the Mullen Rule. So anybody that's there, anybody that's at that table, they're part of the quorum now. So you have to be careful of those things. So if you do that when you're missing 2 members, those members are not eligible to vote unless they do the Mullen if that's their second meeting. So it's always best when you continue a hearing just to continue it. Don't ever discuss what the next steps will be, nothing like that. Obviously they can report that to the staff person ahead of time, something like that, but because if you want to know the reason for continuing, that's fine, but you really can't get into anything with them at the time. For public records, all records made or received by a governmental body, office, or employee are public records unless there's an exception, which is, for example, attorney-client privilege. So emails from us are not public records. Emails are public records unless there's an exception, and they also include text, social media posts, and other electronic communications, even if sent from a personal email account. Minutes and file documents are public records. Minutes must include the date, place, and time of the meeting, the members that are present and absent, the topics discussed, and the motions and votes. You do not have to have a transcript of word for word what happened at your meeting. Nowadays, every meeting is recorded, so you definitely don't need a transcript. The conflict of interest law is next. Municipal employees must, oh, I'm sorry.
Just on open meeting law, one of my personal pet peeves, it's important that we don't discuss anything that we have deliberative authority over that's not on the agenda.
Correct. Absolutely.
That's something we sometimes fall into a trap of talking about something that's not on the agenda.
And you know what's very, very dangerous is the provision that says any topic that's not anticipated by the chair. That is an absolutely narrow item. That means that if, for example, something came up through staff in the past 48 hours, meaning that there's, a seminar, a CPTC seminar that's going to be, held next week, that can be announced, something like that. Not anticipated by the chair is not like an application that's before you that's not on the agenda. It's not about an application that's coming to you that hasn't filed yet. It's very, very narrow. And you're right, you cannot discuss any project that's not on your agenda, that's not listed.
So that's a good point. So what if you have like the agent had a person bring up a complaint within the last 48 hours and was in the meeting, and so in the unexpected stuff, can you say, I got this, I'm going to be looking into
Yeah.
it, and that's fine?
That's
You
it.
can't go, okay,
Right,
just wanted
that's
to-
it. And so, with a Conservation Commission, with an enforcement order, the agent can issue the enforcement order without the board. It has to be ratified at the next meeting. So, the agent or the chair, excuse me, it's the agent or the chair can issue an enforcement order without the board, but it has to be ratified by the entire board at the next meeting. So that is something that can be done, yeah. So with, yeah, sure.
So if you have a continuation of a meeting and it gets continued, but yet a board member or member stand outside and talk to the people who just got canceled, is that proper?
No, absolutely.
So nobody should be standing around any buildings talking after a meeting with an applicant or okay.
Correct. You know, honestly, you know, I served on boards in my town for probably 20 years. It's difficult. It's difficult when you're at the supermarket and somebody was like, oh, you know, we're coming before you. And you just have to politely say, we can't discuss this. Not at all. If somebody's outside and they're discussing the Patriots, that's fine. But you cannot discuss a project with an applicant or, and you also want to stay away from, you know, abutters that are, you know, that have issues with the project too, because technically they would be offering testimony. So you want to be careful about that. If you do encounter somebody that has a problem with a project, you want to encourage them to come to the next hearing. Or send in something in writing, you know, which is always helpful. So with conflict of interest, municipal employees have to receive a summary of the law, and all municipal employees, which are board members included, must complete an online training program. And generally, do not act if you have a financial interest, if you're related to the applicant, if you are an abutter or a close resident, or if you have bias of any kind. If you are an abutter or a close resident, it actually means that you have a financial interest. That's the way that that's interpreted, so you don't want to act. And I can't tell you what close means, unfortunately, but it's close, you know, abutter or close. So under Chapter 268A, Section 23, that is a code of conduct that's applicable to all municipal employees, regardless of whether you're compensated. So that is board members. And you may not, under 268 23B2, you cannot solicit or receive anything of substantial value, which is $50 or more, because of your position or you're used to attempt your office to obtain any unwarranted privilege or substantial value not properly available to similarly situated individuals. So examples include using information from your town position to benefit yourself or someone else in private capacity, such as a teacher tutoring their student for money, or using a mailing list, phone or address list available to you in your town position, or solicit new customers for private business or political campaign, using town equipment or other resources for personal use. You cannot, under 23B3, a municipal employee cannot act in a manner in which would cause a reasonable person having knowledge of the relevant circumstances to conclude that the employee are acting with bias, favoritism, or otherwise personal reasons. And you know, municipal employees can refute such a conclusion by filing a disclosure with their appointing authority, if elected, you know, with the town clerk prior to taking action on the matter. That's when there's a possible conflict. You just want to clear it up, so you file a form with the town clerk that says, here's, people think I have a conflict, I don't think I do, but in any event, I'm going to act, you know, within my position without bias. The other thing that's very important is that under the, actually, I have a slide on it, so I'll wait. Restriction on gifts is you may not accept a gift of substantial value. And then the regulations are 930 CMR 5. Some gifts are exempt, but they do, and some require written disclosure. Others are absolutely prohibited. But exempt gifts are if it's entirely unrelated to the employee's office or any official action, for example, a birthday present, something like that. Going back, under 930 CMR 5, that is the state ethics rules and regulations. If you ever have a question as to whether you should act or should not act, the State Ethics Commission has a hotline that you can call, and they will call you back within, usually within a day. They'll call you back, you will speak to a lawyer that works for the State Ethics Commission, and you will get an opinion from them. And if you could get an opinion from your own lawyer, you could get an opinion from us, but the opinion from the State Ethics Commission is what matters. So you just want to call them because it's a free service that they offer. Acting as an agent for a private party, so under Section 17, you may not receive compensation from anyone other than the town, or act as an agent or attorney for anyone other than the town with regard to any particular matter in which the town is a party or has a direct and substantial interest. The purpose is to avoid the appearance of actual or divided allegiance. A special municipal employee are prohibited only from acting as an agent before their own board or office. So if you are a municipal employee and you are an attorney, you cannot, and I am on the planning board, I cannot represent somebody on the Conservation Commission unless the select board has designated me as a special municipal employee. And it's not me, it's the position is designated as a special municipal employee. And those records are usually kept by the town clerk's office, who's been designated, who hasn't. And again, for enforcing the State Ethics Commission, enforcing ethics is completely on the State Ethics Commission. Complaints to the State Ethics Commission are confidential. They're often resolved through a private letter determination or advice. They can go into a private, public hearing process if it's significant enough. And it's important to note, no one board member can force another not to participate because of a concern about an ethics issue. It's always on you if you're going to participate or not. That doesn't mean that board member that thinks you shouldn't participate can't call the Ethics Commission, because they can, but they can't say, hey, you cannot act. They also can't tell somebody, hey, you don't have a conflict and you have to act. So it goes both ways. Violations of 268A, they can carry criminal penalties, but again, that's all through the State Ethics Commission. So these are the additional resources that you guys can look at for open meeting law and public records. There's the Attorney General's office. They have the open meeting law. They usually have an open meeting law handbook that I think they actually just recently updated it. And then the public records, their public records law, the Secretary of the Commonwealth has those. So that is my presentation. Are there any other questions you guys can think of? Sure.
For a site visit, there's only so much you can see from the street. What's allowable for us to enter the property? Is there any language in filing that says the applicant is allowing us to enter the property as a review?
So all applications have that says that they can, or conditions. Well, you'll issue a decision that has a condition that says that the planning board and planning board staff and members may enter the property at any time to check for the conditions. That's not legal. You can't do that because there is a Fourth Amendment of the Constitution of the United States. So you have to have permission of the applicant. So a lot of applications will say, by signing this application, you're allowing the agent and members to enter your property. That's iffy. There is the Garrity case that says that no, because that person was forced to sign that waiver. So you want to have the property owner's permission. You can get that permission at a public hearing. You can get that permission, you can get it from the agent. So for example, if you only have their engineer in front of you and you say, okay, we're going to schedule a site visit. Can we do next Saturday? Have the property owner send us an email saying that we are allowed to be there Saturday at 9 a.m. And you can then go onto the property. For enforcement, you can't go on unless you have permission. So you can go on, you can look at it from a public sidewalk or way. You can also ask abutters if you can go on their property to look at what's being violated, but unfortunately, going onto private property is very difficult to do. If the violation is significant enough, and administration allows you to reach out to us, we sometimes will go in for an administrative search warrant, which we will get from the court, and then we can go in and look at the violation. Yes?
So on the conservation issue, if you have an engineer that's representing somebody, and the engineer says that they can go on the property, but he didn't confirm it with the owner, what happens at that point?
I wouldn't go on. I would have like I said, I would tell the engineer, please have the owner send an email to staff. And I wouldn't go on without the owner's permission.
What about the post-construction for an inspection?
They really need to get the permission. Yeah, because it is private, technically it's private property, so. So you have a condition in your, say you have a condition in your decision that
If
allows,
it's conditioned in the decision, then.
and it hasn't been appealed, maybe you have a room to stand on, but again, it's the Fourth Amendment of the Constitution that you can, illegal search and seizure, you can't go on the property without.
But if you can view the progress from the street.
Sure, anytime, yeah. Yes?
So the idea is to eliminate that problem on a decision, you almost have to state that the agent or the board has the right to go on the property? Or is that's again, you're pushing
It's just a
it?
waste of words, in my opinion, honestly, because you can't without permission from the owner. Yes?
If you're an elected official in town or a board member, is it appropriate to approach vendors of the town and/or companies for donations if you're an elected official on a board? So say there was a company in town and you're a member of a board and that company has to go in front of the board, but you've asked that company for money to donate. Is that appropriate? Or
No,
nobody should be doing that?
no, I don't think so. If you're, say you're a member of the Conservation Commission and you want to ask an accounting firm in town that their office is nowhere near a wetland, and you want to ask them to donate to the Kiwanis. I mean, sure, but being an official of the town, you just probably shouldn't. You should have somebody else in that organization do the soliciting for donations. It's probably best. The State Ethics Commission takes a pretty hard line on board members and what they can and can't do. There is one where a board member, I think it was a Board of Health member, and it was a husband, the wife was on the Board of Health, and the husband could not do septic systems in the town. Even septic systems that didn't go to the board, that just were approved by staff, that company, they were told by the Ethics Commission they couldn't do anything. So they really have a pretty hard line on, they hold board members to a higher standard, I guess I would say. So I would avoid that if you could, and have somebody else go and solicit donations.
Is it appropriate that elected officials should ask the town for a list of vendors that we do work with? Is that appropriate? And then they can approach them and ask for donations?
Oh, no.
No. That's an absolute no.
No. I think a vendor list is, that could be public record. And then if it is a public record, again, every decision made by a board member when it comes to ethics is on that board member. So I can tell you not to do it. They can go get an opinion from the State Ethics Commission that's opposite of mine, but then I also wonder what did they tell the State Ethics Commission? Anyway. Yes?
On the ClearGov, if I wanted to go to the town of Plainville and find out who gets paid from the town of Plainville to do work in the town, that's public records. That's available.
Okay.
Am I right?
Sure.
Okay.
So, yeah.
Okay, so I was just rebutting the fact that the gentleman there said that, that.
Well, what happens after you receive the information is what I think is the ethics issue. That's when the ethics comes into it, is what you do with that information,
All
I
right,
guess.
so when the fire department and the police department send out letters to everybody in town, businesses and all.
The union does that, not the fire department or the police.
Huh?
It's either the union or the boosters, yeah. It's
The
not them.
union?
Yep,
So, yeah, but they're town employees.
Yeah, but it's the union that's doing it, not the town that's doing it. It's different for fire and police.
So if you have a 501c and you're not affiliated with the town, you're clear.
So if
So,
you're a board member,
yeah, not if you're a board member, if you're, you know, I
If
mean,
you're a
if, you
fireman
know,
and a policeman,
yeah,
you're working for the town, you're a town employee.
so usually, those solicitations from fire and, police are done by a boosters group, which is through the union. So I don't know this, I don't know the specifics, but usually it's not the actual employees that are soliciting.
They have their name on it. The people that are the firemen, they sign it.
Then maybe you should call the ethics commission, I don't know, but usually.
I'm just throwing that,
Yeah.
we got into the subject, so I wanna just throw it out to let everybody know about it.
But it's usually either the boosters or the union. It's not the actual employees, that's my understanding.
I've heard that people can be sued personally for things that they've said as a member of a board in a hearing or a meeting.
So,
Has that ever happened? Is that?
oh yeah,
cases
oh,
of
it's
that?
definitely happened, yeah, it's definitely happened, and as my,
Give me examples.
we have, yes, there's a case in federal court right now where, a woman has sued, she sued 2 towns and 4 members of boards individually for statements that they have made at public hearings. And we were able to dismiss a few counts, but many of the counts are still going forward, and including the counts that are against members individually. That was, showing an absolute animus towards somebody, stating things like, I don't care what you're gonna tell me, I'm still gonna deny this application. Talking about denying an application before it comes in, before an applicant is even presented. I mean, and there's all different levels of this. I mean, you could say to somebody, listen, you didn't give us plans, you didn't give us anything. We're gonna deny this for lack of information. That's a whole different story. But you can't, as a board member, you cannot say to somebody, listen, you could tell me that, the world is perfect and your project is perfect, but I'm still gonna deny it. You just can't do that. You're sitting, you're in a position where you have to look at everything fairly, you have to look at all sides of everything. Sometimes it takes a while, you have to listen to a lot, but you can always come to that decision after you've heard all of the evidence. You can't do it before you've heard the evidence.
And after you've heard the evidence, is it required that somebody on the board would have to explain why they denied something?
You have to in your decision. To have a defensible decision, you have to say why. You can't say, I'm denying this because it's not right for this neighborhood. That doesn't work. You have to say it, you have to get into way more detail. You cannot say it because, say it's a townhouse development and you say, oh no, we have way too many townhouse developments in town. You can't do that. If it's allowed under the bylaw, so for example, if it's coming to you for site plan, if it's allowed under the bylaw, you have to grant site plan. If it's a special permit, which is a discretionary permit, you have to go through your special permit performance reviews and requirements. And if it meets all of those, you have to grant the permit. It's discretionary, but the discretion is tied to the zoning bylaw because town meeting voted on the zoning bylaw. So that's your legislation, is the zoning bylaw. It's not whether you like the project or don't like the project. And if you don't like your zoning bylaw, get it changed at town meeting, because we have that. We run into that a lot where, the town doesn't want this, they don't want projects like this in town, so go to town meeting and get rid of it. That's the joy of having, local zoning, is you can change your zoning bylaw at town meeting, 2/3 vote, but you can do it. So.
In those instances that you explained that were in federal court, was that because it was something that was simply rejected, or was there actually something beyond that was said in those meetings that was maybe a personal attack or something?
There was numerous, the plaintiff, she files lawsuits a lot of lawsuits against certain towns, and she loses many of them, all of them. And I think I have 13 cases with her between 3 towns. So, and in this particular instance, there was one member that lost his temper at her in a meeting. So the other member that she's suing is beyond reproach. She did nothing wrong, but he was the chairman, so she went after him. But we got that one dismissed. But no, they can sue you individually. It's not often, honestly. It's really not. And usually, if it is, we can get it dismissed pretty quickly.
As a member of the board, is that covered by our agreement with
It's-
KP Law?
It's usually not necessarily with KP Law. It's usually covered under the town's insurance. Yeah. Yes.
And so 2 things, follow up on his, what's the indemnity that the town has? What does the town pay what's the value of it? Does the town have a insurance policy and a certain amount?
They do. I don't know what it is.
Would anybody in this room know the amount?
Probably not. Have you seen an insurance policy? They're quite lengthy. I think you'd have to look in the actual policy to decide what it would be for, and then it would be what did the person actually say, what did the person actually do, and how much is the plaintiff seeking in damages.
And then in a special permit, if it says shall, doesn't that give you more leeway when you're deciding a thing? The terminology in the zoning, if it says shall have this and shall have that and shall have that, and none of that makes it.
No, there was a case, maybe in the past 10 years, there's a case that says that shall equals must.
Shall equals must.
Yeah.
Okay.
Yeah.
That's what I wanted to know. And then, so we don't know the value of that, of the indemnity insurance.
You know, a better idea would be just don't do anything that's going to trigger insurance.
I agree with that, but I think, why have insurance?
That's the advice you take away from tonight.
Tonight.
Here you go. Don't do anything.
I like that.
Yeah.
So from what you've been presenting, it's important when we're making decisions to tie them to bylaws or rules or things that can one of the conditions based on lack of knowledge provided by the applicant be a refusal to allow site visit, for instance? Could that be an element of?
Yes, that could, because so for example, if you are a conservation commission and the wetland is in the center of a 6-acre property, how could you decide if the wetland line was valid? How could you decide if, if a building 25 feet from that wetland, if it would impact the wetland or not? You have to be on site, and so the applicant should absolutely let you on the property. With a conservation denial, if a denial for conservation, if there's a denial order of conditions based on lack of information, you actually, under the regulations, you have to list all of the information that you requested that they did not supply. And so that would be one of them, a site visit. Yes?
Regarding board members getting sued, the volunteer lead shield law wouldn't apply in this case?
No, it does not. And honestly, it doesn't happen a lot. I don't want to panic everybody. It doesn't. No, it doesn't apply. But again, we've had them summarily dismissed. So we've had, we have a certain attorney on the Cape that he always sues the board and the members individually. And so we just always, we dismiss the individual claims and they go away. And then, it's done. And then we continue on with the case. So, yeah. Yes?
Another question. If, say I was looking to build a house, and I was in front of the planning board, and the planning board was gonna make a decision immediately without me presenting my information. That's not right, correct?
Correct.
So you couldn't vote that night on one hearing without hearing, saying myself was gonna build a home?
Right, that's what I was saying, where
Okay, that's what I'm trying to make a point of.
you can't make a decision without hearing the evidence. You have to
On both
hear it.
sides.
So that goes to due process. That's due process, which is, and again, that's the same thing where when somebody requests a continuance, you grant that continuance, they leave, and then there's a discussion about it. Not only is that a violation of the open meeting law, it's a violation of due process, because you're discussing that application without that applicant there.
And what happens if a board or a member on that board violates it? What happens to them? How do they
Well,
get reprimanded?
Well, it could be an open meeting law violation, first of all, which is not good, because obviously, open meeting law violations come with some pretty stiff penalties, financial penalties for the town, so you want to avoid those at all costs.
Thank you.
Anything else? Yes?
So on site plan review, I know it's, you have to grant it if they meet the criteria. So the process going back and forth between the applicant and the board is about, working it so that they meet all the criteria, but a site plan that makes sense.
Yes.
So say, an applicant is refusing to change things, what does the board have for leverage? If they just find the site plan unacceptable, the applicant's not changing things, really, what do we do, just kind of lean on that criteria? And
Yeah.
say you need to meet this.
You have to, yep, you have to, and you have to have really substantial reasons. So for example, internal circulation.
Yeah.
If their circulation makes absolutely no sense, which honestly, there are drive-throughs in this Commonwealth that you could get killed in, because you don't know where to go for the drive-through and things. Like, if it's something like that, you can say, come on, no, this is, even with site plan, I would definitely push back on that, definitely. And screening, they could be providing a couple bushes, and where site plan says that it has to be screened from, if there's a commercial property, it has to be screened from a residential property. You could say 2 bushes that's not screening. You have to have a fence, but better yet, have your bylaws say it has to be a 6-foot fence, or a row of deciduous trees, 6 foot tall at full growth, DBH, all that stuff. The more detailed your zoning bylaw is with regard to site plan, the better off you are. And the other thing that has become a thing lately is in site plan to have design requirements for site plan, and you can do that, but you have to remember it's still site plan. So they're really they're really more suggested, and if you have them, they have to be broad enough. You can't say you have to paint your house pink. That can't be a design requirement. They have to be broad, and they're always better when they're associated with a special permit rather than site plan. Yeah, because we did have, up in Salisbury, I did have a case where design requirements associated with site plan, with a special permit were upheld. And the judge, one of the requirements was a New England character, and the judge kept pressing me saying, well, what is New England character? What is New England character? And I'm like, well, it's a cape, it's a colonial. And he was like, well, no, what is New England character? And I was like, it's not stucco. That was all I could really come up with.
So define that with a set of
yeah. So, but that was a special permit case.
Special permit.
Yeah, and so the board had a lot more discretion.
Your comment about drive-throughs triggered a memory of a case going on not too far from here where a Dunkin' Donuts owner is rerouting their drive-through lanes and removing one, and they came before the planning board and asked for a hearing on a light change as well, 2 weeks after they started work.
They already started?
They'd already started work.
Oh.
The question is, my question to you is, and maybe this is out of bounds for our conversation here, what extra leverage does that give a planning board or a Concom or a select board? You know that is, or is it just, please don't do that, and you listen to them anyway, or can you make that action be a part of your decision?
Oh, definitely. You definitely can. After the fact filing, you always have to look at what they did. You always have to make sure whatever they did it right, and particularly for conservation, you have to make sure that whatever they did didn't impact the wetland, things like that. But after the fact, applications are, they're never good. They're never good. And then the other thing too that a lot of boards, even all boards, will ask an applicant is anything that has to do with financial or taxes or monetary. That's not in this realm. It's not for land use boards to say to somebody, well, if you do that, are we gonna get a lot more taxes? Or how much did you pay for the property and how much are you gonna make off the property? None of that is particular to a land use board. The problem with that is that if you do end up denying it, you know, they'll claim that it was arbitrary because it was based on financial reasons. Yes?
If the planning board approves a building and says that all the ambulance service has to be done by the town, do they have the right to do that?
I don't think so. I've never seen that before. I guess, so what?
Convenient MD opened in town and the requirement was they couldn't hire a private ambulance service.
Oh, yeah, that you can do. I thought you meant like wherever you, like if you have a subdivision, you can only pick up certain people.
No, so.
That's not right.
So that's acceptable that we say they can't have a public service, a public ambulance company there?
Private.
Right.
A
Did
private?
they appeal the condition?
No.
There you go.
So the last two that we did, we kind of forced them into it, extorted them.
Okay, no, you didn't. No, you
No?
didn't.
Okay.
Nope.
Don't use that word ever.
Oh, I'm sorry.
I'm sorry.
So we back to design standards?
Yes, let's go back to design standards.
When it comes to design standards, we're actually trying to work on that and implement that as a planning board. You had said that it's tied to a special permit. If we try to tie it to zoning, is that?
So you would, it goes into your zoning bylaw. It has to go into your zoning bylaw. Do not do like rules and regulations for design standards. Those have no teeth.
Okay.
If you want, you can look, Lakeville just did them for site plan review. And they have, so then they had they actually had a project come in, and the project was proposing metal buildings. You know, in my opinion, not attractive, metal buildings. And they invoked these design standards. There was litigation involved, but we actually, it settled. And they now, it's a nice project. It looks a lot better.
Typical state hospital.
No, that's still ongoing. It's a lot. No, so, but it really did help the project, and the project looks much nicer than it originally did. So, but again, you know, you have to be careful if it's site plan review, because if the use is allowed, you have to grant it, so, so, that's what design standards. They're difficult, but they're useful, but they definitely have to be in the zoning bylaw.
So the bylaw shouldn't just defer to the planning board to adopt from time to time, even like a visual guidebook should be as an attachment to the zoning bylaw?
Yeah, it should state in the zoning. I can't remember exactly what they say in Lakeville, but they say things like, there's, you know, vertical paneling, horizontal, like they limit the vertical, and they prefer dormers, things like that. If you take a look at them, and then, yeah, and I can find others for you. But yeah, those are the ones I just recently have dealt with.
Thank you.
Yeah. Yes.
You had mentioned, you know, not to consider increasing taxes to the town. Is there any situation where a benefit to the town can or should be considered as part of the conditions?
Well, that, yes, yeah, I mean, in the special permit, there's often, you know, a benefit to the town, but that's one of many, I hope, that's not the only criteria. You're on the zoning board, right? So for the zoning board, it would go to the hardship. So a hardship can also be a benefit to the town. The hardship can be that we're offering a benefit to the town. But generally, no, it should be, I mean, with regard to a special permit, if the project enhances the zoning district, that's allowed. You know, you can say that the project should enhance the zoning district. But again, if it's, you know, you have to look at the project specifically, what it is. But it should never be, it's going to bring in more taxes. Anything like that. The only time you would ever get into finances is with the 40B and the 20%, the 20% profit cap. That's it. Anything else? Yes.
A presentation like this was done maybe 3 weeks ago by KB Lodge in North Attleboro.
Mhm.
Might even been done by you, I don't know.
It wasn't.
I was wondering if you knew whether it was similar, the same, or very different.
Do you have the
Only because they
timeline? Did you
recorded.
see that one?
Don't know if I saw the North Attleboro one. This one was based off of one we did for CConk in
Okay.
July, and then a couple more recent ones by I think Carolyn and the other.
So we will do them for, anybody that wants it. So sometimes I'll do them just for a conservation commission and I get way more into Concom stuff, or we do them for a planning board, we get way more into, like for example, with a planning board, I would have at least 3 slides on 48 section 5 zoning amendments to the zoning bylaw, things like that, and the procedure and how you go about doing that. But here with land use boards, this is way more general.
Thank you.
Okay. That it? I'm here, it's okay. Nope, all right. Thank you, everyone.
Thank you.